What happens after a first-time DUI arrest? This video is for people that are experiencing their first DUI arrest or people that love them and trying to figure out what's going on. But this video is specifically for people dealing with a DUI arrest for the first time. We're not going to talk about what should have done during the actual DUI stop, what the officers can and can't do. We're not going to talk about the field sobriety test. Other videos for that. We're talking about what to expect, what's happening, and just trying to explain what's going on with the first time DUI arrest. So let's jump on in. One of the most important things to understand is in Indiana, a DUI is actually called an OVWI, operating a vehicle while intoxicated. That's the official term for Indiana. It's not OUI, DUI, DWI. Those are all the same thing in Indiana. It's OVWI, operating vehicle while intoxicated. And it's actually more broad. Now, in some states, the designation DUI, OUI, DWI all mean something, but it does not matter. It's all the same thing in Indiana. So there's no nuance that some states have. I know in Illinois, Wisconsin, Michigan, there's versions, wet, reckless even. No, it's all OVWI here in Indiana. So people all the time call me, Mark, no, I don't got an OVWI. I got a DUI. No, it's all OVWI. Why is that important? Because my website uses the terms interchangeably. I will say them interchangeably. They're all the same thing. You do not need to stop and figure out, hold on a second, what's a DUI versus OWI? They're all the same in Indiana. DUI charges. Let's start with the basics. In Indiana, almost every single DUI case is actually 2 charges or more in some cases. But there is operating a vehicle while intoxicated. That's the first DUI charge. And then there's something called the per se charge. And that's operating a vehicle with a blood alcohol concentration of 0.08 or greater. Operating with a blood alcohol concentration of 0.15 or greater. And there's even operating with a metabolite in one's blood. So there's 3 different versions of the second type. It gets crazy kind of fast, but it's not rocket science, believe me. But there are lots of different things going on with DUI charges. So don't freak out if you're looking online or you go to court and they're reading lots of different things. And that happens all the time. Mark, I got charged with DUI, but they've charged me with 6, 7 different things. In fact, Boone County charges everything under the sun. You'll actually see a DUI case with like 17 charges, and it's like, oh my God. And people start feeling intimidated by that, but don't. Take a deep breath. There's going to be more charges with a DUI than with a non-DUI, just because of the way the statute and law are set up. So take a deep breath. Don't get stressed out. But let's break this down a little bit more. Every single DUI case starts off as a C misdemeanor. Now, it's because it starts there doesn't mean it's finished, but a C misdemeanor, operating a vehicle while intoxicated, operating a vehicle with a blood alcohol concentration of 0.08 or more. Those are the building blocks of a DUI. Now, operating a vehicle while intoxicated, if you throw in a little bit of endangerment, not a lot, a little swerve, maybe some excessive speed, maybe not even that much excessive speed in a neighborhood, but just a dash of endangerment, the operating a vehicle while intoxicated as a C misdemeanor turns into an A misdemeanor. A misdemeanor is 1 year in jail max. C misdemeanor is 60 days max. So we don't want it to get higher, but that does happen. Same thing with the per se charge. Operating a vehicle with a blood alcohol concentration of 0.08 or greater, that's a C misdemeanor. If that blood gets to 0.15 or greater, that turns into an A misdemeanor. Again, A misdemeanor, max 1 year in jail. C misdemeanor, 60 days. We always want the C over the A. Now with the A misdemeanor intoxicated charge, people call all the time, hey Mark, no one was endangered, I was just driving. The rules for endangerment in Indiana are unfair. They're not right. I don't agree with them, but the reality is those are the rules. And the rule is if a hypothetical person could have been endangered, then it's endangerment. So people get pulled over all the time. They're the only one in the car and there's actually no one on the road. Well, they were swerving. That could have hurt somebody. Their tires went onto the double yellow line. Oh, that could have caused an accident. So it's one of these few crimes that exist in Indiana where a hypothetical person could have been hurt and it's enough for endangerment. We fight endangerment all the time. We're constantly pushing the envelope and trying to fight back on these, but just understand the law in Indiana, endangerment is a very small burden. So don't get upset if you see the words endangerment. People call all the time, oh, it's not fair, I didn't do that. And I get it. It doesn't look very flattering on paper, but take a deep breath. That's what you got an attorney for. That's what we'll help you with, and we'll fight that tooth and nail. Now, in some rare circumstances, and maybe not so rare, a first DUI can be a felony. And normally felony DUIs are reserved for people that have prior DUIs. typically 2 within 7 years. But it can be a felony for a first-time DUI when and if a passenger under the age of 18 is in the vehicle. That is one of the more common ones, if that's describing your situation. Finish this video, but it's super important to click the link in the description for DUI with passenger under the age of 18. There's all sorts of special things that have to get done because it's very serious, very fast with a passenger under the age of 18. Lots of judges and prosecutors get upset about those type of DUIs. Keep watching this video, but there's a link in the description. Click that link and watch that video as well. So having a passenger under the age of 18 is one way to make a first-time DUI into a felony. The second one is if there is an accident and people are seriously hurt or worse. Again, don't stop watching this video, but we have other videos and I'll put them in the description if that applies to you. You want to finish this video and then immediately go and watch those videos if that describes your situation. A small side note. If you've been in an accident and you were drinking or might be something in your blood that shouldn't be there, or even if it should be there, but maybe not in the right dosage, prescription medication may be taken too frequently. Sometimes DUIs with accidents don't get filed right away. Sometimes it's human nature to say, well, I'm not going to deal with this problem until I know it's a problem. If there's a DUI with accident, or if there was an accident and you even suspect, even the tiniest little bit, there might be a DUI coming, there's things we have to do now to make you look better when and if charges are filed. And Indiana has 2 years to file charges for a DUI. And if it's more serious because someone was hurt or even worse, it could be even longer. And the last thing we want to do is go to court a year, 6 months, a year, or 2 years later, and a person hasn't done anything, because that's going to look very, very bad. And the judge is likely going to want to make an example. The prosecutor want to make an example out of you. So if there's even the smallest bit of you that suspects that accident might turn into a DUI, you want to take massive action next. How would someone know if their accident might turn into a DUI? Well, it's a great question. Did an officer ask you about this? Did an officer speak to you about what was going on? Did an officer ask you where you've been? Did they take blood from your arm? Were they blowing into the breathalyzer at the station or other places, even at the side of the road? So there's usually clues as to whether or not an accident is going to turn into a DUI, but you owe it to yourself, even if there wasn't blood, even if there wasn't a breath test. If there's an accident and you were at a bar, you owe it to yourself to call an experienced attorney to make sure you're putting your best foot forward. Enough of that. Let's keep moving on. Even with the first-time DUI, there is going to be a driver's license suspension. Now, I'm talking to people that agreed to take a chemical test, not people that have been charged with the refusal. Now, if you've agreed to take a chemical test and your blood or breath is 0.08 or greater, the judge at the first court hearing is supposed to take away your driver's license for 180 days. But Mark, I have to drive. I got it. Let's talk about that. So this taking away of the driver's license at the first court date, it's not fair. It seems anti-American. I didn't do anything wrong. I'm innocent until proven guilty, and I get all of that. But Indiana and most states have created this exemption for driver's license. They call driving a privilege, not a right, so they can take it from you if there's probable cause for an arrest. Now, Indiana law specifically says they're not supposed to take the driver's license away unless there's prima facie evidence of intoxication. Prima facie evidence is defined by a blood test or breath test of 0.08 or greater. That's prima facie evidence. Now, some judges don't agree with that, and that's okay. Most judges do, and they will not take away a driver's license unless there's a prima facie evidence, 0.08, blood or breath. There are some counties that do that. Now, if you're in one of those counties, we won't know until you call me and figure it out together. But regardless, if they're taking away the driver's license, we are going to try to get your license back to the magic of SDP, Specialized Driving Privileges. This is something that came into existence in 2014, so the first 6 years of my practice, this didn't exist. This truly is magical because it allows a person to drive to and from work and other life's necessities while case is pending. Now, SDP is not automatic, and in fact, it's up to the judge's discretion. And there are some really weird situations here in Indiana where Judge A allows it, but Judge B doesn't. Specifically, Shelby County, Hancock County. They don't grant STP. They just said, no, we're not going to do that. And that's fine. That's their prerogative. And we have lots of judges in Marion County. Some judges will grant it. Some judges won't. Some judges say, Mark, what was the breath alcohol? Oh, that's too high for me to grant. Some judges will say, hey, there's an accident. Nope, we're not going to get it. How fast were they going? So even within the county, there can be different judges, different reaction to STP. So specialized driving privileges is not guaranteed. But there are some things that you can do to increase the chances of getting an STP. And I will help you with that, but most of these are involved being proactive before we get to court. So even when the judge is mad at you, I'm not going to give this person the ability to drive. Mark, they're going 25 miles over the speed limit. Judge, I get it. But look, before they came to court, they did X, Y, and Z. Take that into consideration. So there are things you can do to put your best foot forward to try to get a driver's license. Now, if you are one of the unfortunate people that have been accused of refusing the chemical test, it's a whole different ballgame. Refusal comes with an automatic 1-year suspension, plus that means on top of up to 1 year for actual DUI, assuming it's not a felony. So people that have a refusal, they really have 1 year guaranteed plus another year on top of that. 2 years license suspension. There are some tips and tricks about that. I'm not going to get it into the video because they are so county specific and they are so judge specific where I don't want to inspire false hope with anybody. But if you have a refusal, you owe it to yourself to call an experienced DUI attorney because we don't live in Chicago. We don't live in New York. We need to drive. We live in Indiana. Driving is important. And the last thing you want to do is get caught driving after a judge says don't drive, because that makes judges very upset. And it makes judges feel like perhaps you don't respect their authority, and they typically deal pretty harshly with that. So I want to get all my clients driving. Refusals are very tough, but I got game plans and I got backup plans for my backup plans. Call me to try to figure out this refusal situation. What to expect in court for your first DUI? Well, every single case in Indiana requires an initial hearing. So initial hearing is basically where the judge reads the charges out loud. You have been charged with operating a vehicle while intoxicated. It's a Class A misdemeanor. You have been charged with operating a vehicle with a BAC of 0.15 or greater, a Class A misdemeanor. But they have to read the charges out loud. There's lots of reasons for that, but it stems from distrust in government where we want to know what's going on. We can't just go to court and not know what we're charged with. So the initial hearing is a great way to remedy that. Hey, you were charged with X, Y, and Z, and you know what it is. It's read in public. Now, the reality is, this is modern times. We have computers, we have lawyers. We know what we're charged with. So if it's a misdemeanor, in almost every court in Indiana, there's one notable exception, you can waive that first hearing so long as you have an attorney and they sign some dotted line and file it ahead of time. You can waive the initial hearing. So don't call off work just yet until you've spoken to an attorney. There are some counties that require people to come even for their misdemeanor initial hearing. They're few and far between and they're fading fast, but there are one or two and it's super inconvenient. But hey, you know what? It's a judge's choice. The judge can do what they want. So don't call off work for initial hearing until you talk to an attorney. And quite frankly, there are things we rather have our clients do while the initial hearing is going on than they come to court, because initial hearing is one of the few hearings where the prosecutor doesn't even have to come. But most prosecutors are there. It's usually overfilled with people. There's not very much face time with the prosecutor, but they do exist. Now, the real show for DUI cases is the pretrial conference. Now, in some counties, a pretrial conference is super important. The prosecutor and the attorney will get together and talk and mesh things out. In some counties, it's a giant, what they call cattle call. There's 10 attorneys, 50 defendants, and basically there's exchanging paperwork, and the prosecutor's like, if you have any issues, email me. I don't have time to talk. So it's all over the place. A lot of the real magic happens with DUIs between hearings with emails. And then even a little secret, when we go to court on other cases, we'll bring files with us. Hey, let's talk about this one real quick. Hey, let's get this done. Hey, let's get some movement. And then that's the real deal. And pretrial conferences for criminal cases, you must be present. Sometimes people get confused. Well, Mark, I didn't come to the first one. What, I've got to come to the, you just have to. Well, Mark, I had other legal case. I didn't have to. I'm telling you right now, you have to be there unless the judge excuses it in writing. There are a few counties, again, few and far between. Judge is 100% cool with the person not coming. But almost every county, you have to be there unless it's excused in writing. And typically, judges do not like granting things without at least 48 hours of business time. Not weekends and Saturdays. We're talking if the hearing's on a Wednesday, we got to get this motion for attorneys only filed on Friday to give the judge 48 hours to review and respond. That's a good rule of thumb. So last minute things don't typically work out too well in criminal defense, because the judge has lots of power and the judge does not want a person to think they can just do what they want with these cases. So judges have to run a fair and efficient courtroom. Don't always have to come to court, but you have to be there unless your attorney tells you you are excused. Now, after the pretrial conferences, and there can be more than one, there can be more than two, there can be more than three. Depending on the issues, there might be more than three. Depending on the driver's license situation, we may not be in too big of a hurry to get the case done, depending on all sorts of things. Sometimes we just have cases that clients need us to drag out make their situation better. Sometimes clients need time to get treatment. Sometimes I need time to make sure someone that's been injured in an accident is going to be okay, or they're getting better. Sometimes you just need time, but Regardless, there may be more than 1, 2, 3, 4 pretrial conferences. Don't get stressed out about that. Now, after the pretrial conferences, there's either going to be a plea or there's going to be a trial. Client has to be there. In some rare circumstances, we can do telephone or Zoom, but that's kind of fading away in Indiana at this point. But client has to actually be at a guilty plea. And essentially at the guilty plea, that's when the judge slams the gavel, and that's when the punishment begins. Now, other videos on pleas, and the attorney will talk with the person about what's going to happen at the plea hearing. Now, the other type of hearing that can happen after pretrial conferences is trial. Indiana has two types of trial, a jury trial and a bench trial. Jury trial, just what you see on TV. Now, if it's a misdemeanor or even level 6 felony, there's only going to be 6 jurors, not going to be 12. That's just the way it is in Indiana. If there's a bench trial, there's not going to be a jury at all. There's going to just be the judge, prosecutor, defense attorney, client. Typically, the prosecutor will have a police officer as a witness to assist them. They just want to make sure the story's straight, but that's what it is. Other videos on jury trials, bench trials, but your attorney will guide you if they think a jury trial or bench trial is appropriate. And it's always the client's decision though. Client gets to say, hey, I want a trial. I don't want a plea. And that's awesome. Doing trials is one of the best parts of my job. And all the attorneys here, we love doing trials. I only hire attorneys that know trials, know how to do trials, like trials, don't show an aversion to trials. So trials are important, especially for DUIs. There's so many attorneys saying, nothing you can do with this. You can't fight a DUI. It's nonsense. So that's kind of the outline of what happens at court. Now, potential DUI penalties for first-time offenders. Now, the first and most obvious one is driver's license. The penalties for a DUI, including first-time offenders, well, jail is on the table, unfortunately. Now, jail is not a realistic option for a first-time offender with no type of aggravating circumstances. Now, jail does become more likely for first-time offenders if there's excessive speed. There you have some judges that look really, really hard on excessive speed and drinking, especially if a person has a bad driving record. There are judges that want some jail time if a person is driving intoxicated in a neighborhood or children present, or God forbid, during a school zone. There are some extreme situations where jail time becomes more likely for first-time offenders, and I just named a few, but also if there was an accident, God forbid someone was hurt, or if there's a passenger under the age of 18. Jail does come back on the table, but for the most part, jail is not very likely with a first-time offense, absent those circumstances. But there are some other penalties, and the biggest one we deal with is, well, driver's license suspension. We've already talked about this. We live in Indiana. We have to be able to drive, and not being able to drive, well, I suspect a lot of people that are told they shouldn't drive, they continue to drive. But if they get caught, it makes the judge so mad. So driver's license, usually suspension can be up to 1 year for a DUI offense. If it's only a C misdemeanor, maybe 60 days. But this is something that's all over the place, and it can be negotiated. Probation is on the table. Different counties want different ones. Usually, if you do the things we ask you to do ahead of time, we can try to shorten probation. There's always fines. The maximum fine for an A misdemeanor is $5,000. Maximum fine for a C misdemeanor is $500. There's all sorts of different things that can go on here. But the reality is the DUI case is serious, and it comes with lots of different things. And important to note, the license suspension for a DUI, there's a pre-conviction suspension, and if you're convicted, there's another suspension. So a gift that keeps on giving, and it's a terrible gift. Nobody wants to give it. Can't even send it back. But there are significant consequences. Now, people in medical fields might have issues with DUIs. People who drive for a living are going to have issues with DUIs, and these are independent of the penalties imposed by the judge. So there are all sorts of things on here that can happen with a DUI offense, and they're all serious. Now, I make these videos to try to educate people, not to scare, but to educate. And it's important to know you don't have to go this alone. I'm serious about that. Me and my law firm, we can't say specialize in Indiana, but we do a lot of DUIs. I'm a former DUI prosecutor. I've been to the National College of DUI Defense on their class. I have this really cool plaque about the science of DUI. My attorneys are former DUI prosecutors. I've just got a lot of experience in this law firm, and we will help you. We've seen it all. And that doesn't mean you're not special, but the reality, by seeing so much, we know what's coming, we know what to anticipate, and we know how to fight back. We can help you. If you're dealing with your first DUI, I'm sorry you got to deal with this. I know it's not fun, but you owe it to yourself to give us a call, 317-632-3642. I know we can help make your situation better. Give us a call. Love to talk about your case. I will talk about DUI law all day. It is a legit passion of mine. Spend a lot of time and energy researching this, but most importantly, remember to always plead the fifth.